Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, I'm Natalia Angelini.
And I'm Darien Murray.
Welcome to Hull on Estates. You're listening to episode number 731. Today, we're going to be discussing a recent decision called Watson and Lopes. It's a dependent support case. So, Darien, maybe you can help us dive into some of the facts.
Yeah, for sure. So the deceased passed away in October 2021. She was survived by her daughter, who's the respondent in this case, and the applicant, who was her common law spouse of 26 years. So the deceased and the applicant lived together in a residence in Ajax. However, the deceased owned the property with her daughter as joint tenants since about 2001. The respondent didn't live there with them, but she was on title to the property. So the deceased died with a will dated March 20th, 2018, and in that will, she named her daughter as the sole beneficiary and estate trustee. The applicant was allowed to live rent-free in the Ajax residence for a year after the deceased's death, and he also received the balance of a bank account in the amount of approximately $8,000. So the applicant lived in the property for about 10 months following the deceased's death. During that time, he paid the utilities on the property, and then he moved in with his daughter in BC. He commenced his dependent support claim in November 2022. So his claim was that he was entirely dependent on the deceased for shelter and financial support, and that she didn't adequately provide for him in her estate. So just kind of a high-level overview of the claims he made in the case. He said that he was relying on a $300,000 inheritance that the deceased had received from a family member to supplement his pension once he stopped working. And that 1 year of free rent wasn't enough support for him. He claimed that he contributed financially to the Ajax residence, and as such should have a beneficial interest in it based on a resulting trust. He also claimed that the respondent held her interest in the Ajax property on a resulting trust for the estate because she received that interest for no consideration. He said that the deceased promised to transfer title of the Ajax property to him, that the deceased had a legal and also a moral obligation to provide for him financially. And he said that his current financial situation was so precarious he couldn't afford housing. And he was claiming the entire value of the estate, which was approximately $795,000, saying that that was required to maintain his standard of living to live to the age of approximately 85. So the respondent in this case, oh, sorry, go ahead.
No, I was going to say it's an interesting set of facts, right? Because we've got alleged long-term spouse living in the home and, was given a limited interest in the will and is now fighting to get more, right? And the analysis is pretty interesting because, and I know you might get into this in more detail, but he was unsuccessful on almost every front, wasn't he?
Yeah, the court had a big issue with credibility and the lack of evidence in this case. I also found interesting too, reading it myself, he's claiming that he is a dependent and was fully dependent on her for shelter and financial support. But then the large bulk of his argument is that he was paying for a lot of the shelter expenses and supporting them. So it's a fine line he was kind of walking there in his argument.
Yeah, that stuck out to me too, this sort of inherent kind of inconsistency that on the one hand, you were the primary breadwinner for so long, but then in the end, you needed support from the the deceased upon her passing. So, I have to admit, my heart kind of went out to this applicant because there is so little, at least that we can see, that he does have, but the court, I guess, really held him to the obligation to prove and put in that corroboration evidence further to Section 13 of the Evidence Act, which he was not able to do in several respects, right, with respect to several parts of the claim.
Yeah, I did I liked how often, or I found it interesting at least how often they kept coming back to that, corroborating evidence, because we do often talk about Section 13 of the Evidence Act, but I have found, at least personally, that it doesn't actually fully come up as, something that's going to win you the case, so to speak, all the time. And in this situation, it was almost like every single argument of his did get shot down by that, lack of corroboration, unfortunately, for him.
Right. And so you sort of, I mean, I imagine, look, we're not there and we don't see, it's quite a detailed decision though. So you do get a detailed sense of, in respect of each claim, why Her Honor found that it wasn't, it wasn't satisfactory or meeting the requirements in order to be granted that dependent support, except for one, right?
Yes.
So that's the moral. This is where it was kind of nice to see the court applying Cummings and Tatarin and the moral obligation, because in Ontario, we've got, we've seen like tons of cases where those cases are sort of noted, but the analysis really leans heavily into the needs and actual, numbers.
Mm-hmm. Yeah, it's nice to have kind of another case added to that growing bank of case law that does actually address and delve into the moral obligation perspective of it, because it's not, like you said, it's not what's focused on most. And it is such a kind of gray area. There's not as much out there to kind of look to and say, okay, yeah, here's what your moral obligations should have been. So it's nice that we have another case now that does kind of address that.
Right. And I mean, Her Honor, look, it looks like she gave him a bit of a token amount, because she said you get $50,000. And he wanted, right, the whole estate, almost $800,000. So it's really a win for the respondent adult daughter of the deceased. However, I guess the softie in me still, I sort of wish it was a little more, because, we've got a 71-year-old applicant who, although he didn't have the evidence to support all of his claims, and perhaps wasn't a credible, what he did put forward perhaps wasn't credible. But when you look at the equities, right, the adult daughter is really walking away with the property and the property was sold, right? So the net proceeds. But in contrast, she also was able to successfully put in evidence, right, showing that she had contributed to the property.
Yes.
So perhaps I shouldn't be too sympathetic, but I'm curious to see what other cases that are going to be coming down that are actually going to be granting awards and perhaps token sums, perhaps more on the grounds of the moral obligation.
Yeah, it will be very interesting, and especially if we can get a lengthier decision too on that moral obligation side, to see what factors are really brought into that overall decision too.
Right. And the court was careful to, the court is balancing this line of, we don't want to upset testamentary freedom, right? So I think that's where Her Honor was sort of being careful and granting this amount without upsetting the testator's testamentary freedom.
Yeah, that is always such an important consideration. We value testamentary autonomy so highly that we can't just be, kind of overriding that at any turn.
Right.
So I liked that kind of conversation was brought into this case as well. I found that very interesting.
Yeah. Okay, so did you have any other thoughts on the case, Darien? If not, I think that wraps up our podcast.
Yeah, I think we've touched on the few things that I had wanted to discuss as well.
Okay. So, so that concludes our podcast. Until next time, we want to thank you for listening. I'm Natalia Angelini.
And I'm Darien Murray.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page on our website.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.